And we are back on Open Line. Chuck Long here with attorney Kevin Kennedy. It is Ask an Expert on the show this hour. Phone's very, very busy. Kevin, I tell you what, so many topics that they're calling about, and I love this. We're going to go right back to the phones. Again, thanks for the patience. And as we go to Irma right now, Irma, thank you so much for calling in this evening. Do you have a question or a comment?
You may recall last month I called you about a debt collection case where I was being called by a debt collector who was looking for somebody else at a different address and so forth. And you were very encouraging, and I had my trial today in General Sessions Court, and I think I snatched defeat from the jaws of victory. And I'm trying to sort of backtrack, and maybe you can kind of talk in general how these things should be handled. This was a Florida corporation that hired a Minneapolis attorney, and as I told you at the time, that attorney was not licensed to practice.
That's right.
So I had some communication from him. He wanted me to make a settlement demand, and I said, make me an offer, and I'll be happy to entertain any offer you care to make. Well, he didn't do that, and that was kind of the end of it, I thought. And then this morning, a Nashville attorney showed up representing them.
I knew that.
Basically, I was told that I didn't have any proof. I mean, I cited the Fair Debt. I can't remember the name of it, but you know what I'm talking about.
Fair Credit and Debt Act. You're right. Go ahead.
And basically, what the judge, he didn't dismiss it, but it was the equivalent of a dismissal because I'm trying to remember what the term is. You know what I'm talking about, where the judge says that.
Was it a non-suit?
No, very similar to that, though.
Well, I was anticipating when you said, and you can call their hand. Sometimes a Minnesota lawyer will call you and say, well, you got to do this. And so if they were bold enough to come in front of the court, you could call them down and say, Judge, this man does not have a Tennessee license. If he does, let him present it. But we would maintain he's not able to represent. So that guy thought that you were a little slicker, and he had a Nashville lawyer representing them. So touche to that degree, because that could have been the whole case there. You never know when one legal maneuver will win a case or lose. Also, I always say, creative. And I had one of the young lawyers ask me, said, Mr. Kennedy, what book did you find that? I said, hello, come in. The real world, we discuss these things and we try these things. They say there's 9 ways to skin a cat. Well, in the law, try this. If it works, great. Plan A, Plan B, Plan C. And the best lawyers have always got a plan. And some days we have to have an exit strategy. If we don't get it, we will back up and hit them again, Chuck.
Real world experience. Great way to put it. Absolutely. So
they won't box us in quick, Chuck. And they get us tonight. The first thing I say, Chuck, don't say anything.
All right, Irma, thank you so much for calling in. We're going back to our lines right now. Dwayne is on the line. Dwayne, thanks for your patience. And do you have a question or a comment for Kevin?
Yes, I have a question.
Okay.
When I started to apply for disability, I was sent to a series of doctors. They all agreed I was disabled. Social Security denied my claim. I went to a lawyer. 2 years went by, nothing had happened, so I went and saw him again. 3 weeks later, I got a check. So what did he tell them that I didn't tell him, and he got $6,000?
Well, where you find yourself is a lot like a whole bunch out here. We've got to get the doctors. Everyone says, well, I'm disabled. It's not enough to say that. You've got to get medical proof. The doctors has to agree. They have to say you're 100% disabled, 100% permanently disabled, because see, sometimes it can be interpreted that you can get better or you can be retrained. But if you can get the doctor on your side and he puts that in, you can go forward. It's like a lot of cases. We are right, we are correct, but if the judge, or in this case an administrative law judge, says I don't agree for whatever reason, we have to appeal it. And again, why do you need a lawyer? Because many times people will see that lawyer one time. I can't tell you the number of letters we've written in just the last couple of weeks. One letter, bad problem, they're not moving, but one letter from the Kennedy law firm, it's settled. So you spent a very minimum amount of money that saved you a great deal. So it's an ounce of prevention is worth a pound of cure. Benjamin Franklin said that. Just use it.
And reputation works for a lot. So
well, even you and I. And they say, why do you take these big name guys if you had a problem? Because their name means something. It means they're prepared. It means they have resource. They mean they're going to be responsible. So let's move.
Absolutely. So Dwayne, thank you for calling.
Thank you.
Actually, Thomas is on the line with us right now. So Thomas, we do appreciate you calling in this evening. Do you have a question or a comment?
Yes, I've got a question.
Okay.
I've got a question about a will in Tennessee. I know it would be the smart thing to do to get a lawyer and help make out the will and whatnot. And I thought I heard you say, Mr. Cindy, a couple of months ago on a show that in the state of Tennessee, if I was just to sit down and write out my own will, that it would be valid in the state even without having a lawyer involved.
Yeah, it's called a holographic will in the state of Tennessee. You sit down and write it out in your own handwriting, and you sign it. That is the law. Again, I've dealt with those things over the years. If there's anything substantial, it's going to be attacked from every source. And people come to me and say, well, Kevin, it's in black and white. Remember, this group of lawyers and that group of lawyers, everyone's going to have their own interpretation. They say, well, you know, I had a prenuptial, Kevin. That's going to be the end of it. I said, no, my friend, that's really the beginning of it. And so we deal with will contests and disputes all the time. What's Kevin Kennedy's advice? Go spend the minimum amount and get a will. You will sleep better. Your family will be happier. And quite frankly, it'll help you with your taxes, the estate. So you do have that. It is a legal right. And you have a legal right to go to Metro tomorrow and represent yourself. But they said in the law school, the lawyer that represents himself has a fool for a lawyer and a fool for a client. So would I ever do that, or would I recommend for Chuck to do it? No. And if we got in trouble, we're going to get lawyers and we're going to advance. And the odds are we're right. We're not going to advance a wrong claim, and we're going to come out victorious.
So interesting to know that and good to learn. All right. So thank you so much, Thomas, for calling in this evening. Right back to our phone lines. And again, thank you so much for calling in. Please be patient. We're getting to as many calls as we possibly can. We're going back to the lines, and Jeremy's on the line with us. Jeremy, good evening. And do you have a question or a comment?
I've just got a question.
All
Okay.
right.
Okay, I'm kind of in a little bit of a mess, but anyway, the question I have is, I have got a agreed temporary order, which becomes an agreed order after 90 days.
Okay.
A permanent order. So, and in it, it states it's as far as claiming like my son on taxes.
All right.
And it says the parties shall have joint custody of the son, with no party being the designated primary custodian.
Okay.
Financial custodian. No party shall pay child support to either party, and the parties understand this deviation from the Kentucky Child Support guidelines. And then it says the respondent shall claim the party's infant child every year for tax purposes until the petitioner maintains gainful employment for a period not less than 6 months, at which time the party would start alternating years in claiming the infant child, with the respondent claiming the infant child in even years and the petitioner claiming the child in odd years, which I'm the respondent.
Okay.
And she's the petitioner.
And that's pretty clear. And so wherever you and she fall, just about any reasonable person can read that court order. And if you fit within that box that you're employed, then it goes to the alternating years. And the point that I like to make with this, if it was signed as a temporary order, they said, we just have a temporary order. Let me make this clear. A court order is a court order, and it'll be a court order unless another judge changes it. So we have court orders when babies are 6 months old. Those are never challenged, and the baby's carried on until they're 18. And remember this, you can actually agree to more than you're legally obligated to do. In Tennessee, we're not obligated to provide a college education. But if I say, you know what, I'm going to pay for the college, then I can be bound under contractual law. And we do that, but I like to put some stipulations. It's got to be a full-time student, got to maintain a C average, because otherwise you're paying and you just keep on paying. That's where a good lawyer, skilled in that service, will be a lifetime of benefit to you and your family.
And that's what it's all about, the skill that the lawyer has. So
Yes.
that's, again, very, very important. Jeremy, thanks for calling in this evening. We're going to the lines again. Rosalie, we're glad that you called. So do you have a question or a comment for Kevin?
Yes. I had lived in an apartment. This is about apartments.
All right.
I had lived in an apartment in the Hillsborough Village, and some old friends from my high school I graduated from in Nashville helped me neaten up the apartment. And the manager said I was having to leave because of clutter. Is that a legal reason for having to leave an apartment?
Well, great question. I'd go back to my lease document. Remember, we have lots of rights, but you can contract away those rights. It needs to be informed, and there needs to be a mutual meeting of the minds. So if they said, these are the terms and conditions of your lease, you can rent this for $550 a month, and you got 5 pages of things that you can't do and exclusions, then they can operate under that. What they cannot do is violate public policy or violate an existing state statute. So that may be something that you can rely on. Normally, it gets back to an interpretation. What is clutter? You maintain, hey, I had some clothes over. That's not clutter. So you certainly have, pull the lease out, go see a lawyer, lots of free initial consultations, and get their opinion. And if you don't like their opinion, go to another lawyer. All the time I have people come to the Kennedy Law Firm and they say, well, I've saw a lawyer and he said you can't do this. And I said, if you don't want somebody to do something, go back to that lawyer. Our goal is we're going to move forward. And a great one that I just think that just came at the top of my head, Chuck, everybody says, well, grandparents don't have any rights in Tennessee. Well, hello, there's lots of court orders out here where these grandparents, how do you explain that, Chuck? Because those lawyers, when they say it's your grandchild or my grandchild, they're going to pursue it. And so never say never. I learned that at the law school some 30 years ago, and I heard the Court of Appeals judge, he said, never say never.
Words of wisdom.
Words of wisdom. I carry them years later, decades later.
All right, Rosalie, thank you for your call this evening. We do have to take a short break. A lot of you calling in. Stay on the lines with us. Get to as many phone calls as we possibly can this evening. So come on back with us on Open Line.